On Thursday, July 11th, the Alec Baldwin trial continued with day 2 of testimony. On this day, the jury heard from 4 witnesses talking about the specifics of the manufacture of the single-action revolver firearm which was involved in this incident, and more about the investigation into the live rounds that were found on set. And in the process, the prosecution has been laying the foundation of their case, but not without the defense scoring some points here and there. But at this point in the case, has either side moved the needle at all? Watch until the end and then let me know what you think. Let's get into it. So before we get into the testimony of the day, I do want to note one thing that is already happening in the courtroom, that is the development of what we affectionately on the channel here call Snidebars. If you watched the Hannah Gutierrez-Reed trial, you're probably familiar with the high level of snark that came from both sides' attorneys over the course of that trial. This was particularly when the 2 attorneys were communicating their objections. Very quickly, both sides started doing what is called speaking objections, which is when they start arguing their objections outright in front of the jury, which generally speaking is frowned upon because it gives the opportunity to start grandstanding their side's arguments to the jury. During that trial, it got to a level where the 2 attorneys were essentially tossing personal barbs at one another in the open courtroom, and it just felt so uncomfortable to watch at times. And this is why we adopted the mantra on our channel of sidebars, not snidebars. It means if you have a frustration that you need to communicate to the judge, please do go up to sidebar so that you're not involving the jury in what feels like your personal drama. Anyway, that's probably why Judge Mary Marlowe Summers gave the attorneys a rule going into this trial about speaking objections. It was basically identical to what we just saw in the Karen Reed trial, and that is, when you have an objection, say objection. Don't even say the basis of your objection. Ask to approach the judge on sidebar so that you can get everything on the record. Now, personally, I don't love this kind of rule because I think stating the basis of the objection alone without argument shouldn't be something that is going to potentially or improperly impact the jury. And having this kind of a rule runs the risk of the record becoming unclear if you're not careful. So if there's ever an issue that goes up on appeal, this can make things incredibly complicated. But if there is going to be a rule in the courtroom, I would much rather see it actually get enforced. And in this particular courtroom, unlike the Karen Reed trial, well, here it really didn't last all that long. In fact, already by the end of day 1, we started to see all outspeaking objections by both sides, complete with gestures and eye rolls communicated to the jury. And so after day 1, I was wondering if the judge on day 2 was going to communicate something to both sides, saying something along the lines of like she's not going to tolerate that moving forward. Well, I don't know if she communicated something to them, but the snidebars didn't go away on day 2, and in fact, we saw even worse snidebars. Here's an example.
I'm going to approach and show the witness.
You have got to show Ms. Morrissey.
Yeah, she has a copy.
Well, she doesn't know.
What page you're looking at? I don't know what line you're looking at. You told me I have a copy. I'm assuming it's the previous transcript.
It is. Again,
Page
it's
and line, please.
the body-worn camera from 10/21/21.
Page and line, please.
Page 3, line 1.
Same objection, Your Honor.
What is it?
Ms. Poppell is not Ms. Poppell is not in this transcript.
Well, he's what are you doing? Asking her to refresh her memory?
She was there. I'm asking if it refreshes her recollection.
All right. Overruled.
Now, don't get me wrong. For our purposes here on YouTube, this is very entertaining. We're watching this here, and because of that, we can relax and behave in ways that are different than what would be appropriate in a courtroom. But do I love this kind of stuff for actual courtroom behavior where there are very real consequences to behavior? To a certain extent, it's probably fine, but I do fear that it's going to get to a level where things are going to start getting ugly in this trial, and that could potentially have an impact on the jury, and we want the jury to be making all of their decisions based on the right things, not the wrong things. Anyway, so as you probably figured, day 2 started off with the last witness from day 1, and that was Marissa Poppell. As a reminder, she is the crime scene tech from the Santa Fe County Sheriff's Department, and she was testifying all about how she collected and documented the physical evidence at the scene. And after doing so, she also sent some pieces off to other labs for testing, to include the FBI labs for latent print testing, for DNA, and for the firearms testing to see if it had malfunctioned in any way. She also explained on day 1 what dummy rounds, blank rounds, and live rounds are, as well as how to tell the difference between them. Now, I do have to correct something that I said on day 1, and that is I had previously said that she didn't finish her direct examination at the end of the day, but she actually did. So on day 2, we started with her cross-examination. Anyway, this ended up taking up the whole morning and then went into the afternoon. And I will say, I don't think that the defense needed to take up this much time with this particular witness. This may be at least partly because of the fact that I have a personal preference when it comes to cross-examinations. Now, to be clear, there are in fact many different ways to do an effective cross-examination, and one of those ways can be to slowly grind down a witness until they deliver the testimony that you want to get out of them. But the only problem with that particular route is that this can also potentially grind down the jury as well, and you can run the risk of losing their attention. And after all, if you don't have the attention of the jury, they won't hear your awesome evidence that you spent a long time drawing out of this particular witness. So this is why my favorite kind of cross-examination, if it can be managed of course, is a laser-focused one that goes through the issues as efficiently as possible. You get in, you get your punches, and then you get out with the least blood drawn possible from your side. And when it comes to the testimony of a crime scene tech, in this particular case, remember I said in the day 1 recap that it seems a little bit less likely to me that this case is going to come down to proving what happened here. This is not a whodunit. It's more of a debate about whether movie sets should be allowed to have a separate delineation between safety workers and artists, or if artists can properly be held responsible for safety on a movie set, and whether this particular artist can be held responsible for the safety risks that he may have caused in that particular incident. And so here, the fact that the defense spent basically half the day with Miss Poppell felt like a misuse of everyone's time, although that is admittedly in part because of the fact that defense attorney Alex Spiro seemed to really struggle with some impeachment attempts and with some attempts to refresh the witness's recollections. Anyway, the defense did get some points scored along the way, so let's touch on them. Basically, all of the defense's points on cross-examination had to do with calling into question the sufficiency of the criminal investigation by law enforcement. And when it came to this witness, she was the one who made requests to the FBI, like I said before, to do testing on latent prints, on trace DNA, and the firearm testing to see if the revolver was working properly or if it could have possibly malfunctioned on set. This witness also executed some of the search warrants in the case to look for the source of the live rounds that made it on set. However, she only had so much decision-making authority since she's not a detective and she's not in a leadership role for the investigation in this case. And so this witness could help in highlighting for the defense issues with the investigation to an extent, but really only so much. Anyway, the things that the defense really got into had to do with the time that it took to search the prop truck and the time that it took to search PDQ Props, the prop house that supplied all the props for the Rust set. And if you don't know, PDQ is owned by Seth Kenney, and he played a very hands-on role in assisting the investigation. Going back to the armorer's trial earlier this year, he was a bit of a boogeyman by the defense in that case, as the defense really wanted to try to cast a shadow on Kenney for potentially being a source of the live rounds on set. And I will admit, there were things that came out of that trial that were a little bit suspicious, but in the end, it still was unclear whether we could definitively say that he brought live rounds on set. And at the same time, it was just as unclear that we would be able to say that he could also effectively be ruled out from that suspicion. But anyway, the Baldwin defense here is doing a bit of the same. And so on cross-examination, Alex Spiro was definitely working hard to cast this shadow over the highly involved Seth Kenney. So Spiro highlighted that basically every step of the way, when law enforcement was looking for these live rounds to figure out who brought them on set, Seth Kenney was in fact involved. For example, he unlocked the prop truck for law enforcement. He also unlocked the gun safe inside the prop truck. And he, of course, welcomed them into the prop house when they searched PDQ for more live rounds. And another thing that the defense pointed out was the serious time delay in executing the warrants for the prop truck and for PDQ. To be specific, law enforcement didn't search the truck until October 27th, 2021, a whole 6 days after the incident. It was locked in between, but certainly there was a question as to who had access to the keys in question, and it seems Seth Kenney was one of those people. And then even worse, PDQ was searched like a month and 1 week after the incident. And in between, Seth Kenney, of course, had awareness that they were likely to come looking for live rounds. So both situations arguably give plenty of opportunity for Seth Kenney to toss some live rounds that matched the ones on the set of Rust. And so when law enforcement actually found some live rounds at PDQ when they searched it, it could also be that Seth Kenney cleverly left those behind so that the search team would find them, test them, and conclude that they weren't a match, while also discarding other ones that could have been a match. We don't know that that happened, but it certainly was a possibility that was presented on cross-examination. And on top of that, the defense also highlighted that when law enforcement searched PDQ, they found that the space was a huge mess. The boxes were apparently piled on top of one another all the way to the ceiling. And so Spyro managed to get out of Miss Poppell that although she initially said on direct examination that they definitely did a complete search of PDQ and only found like 6 live rounds, on cross-examination, she was kind of forced to walk that back into an explanation of, oh, well, you know, this was a reasonable search, and so it's my personal belief that we found all the live rounds at PDQ. And the thing is, it's fair to say this is different than being able to say, no, we turned over absolutely everything in that place. And I would put money on the assertion that we found every single live round that could be found there. Anyway, one of the strongest points on this cross-examination was when the defense pulled out a photo that Miss Poppell had taken of some documents that she had found inside the church nearby where Halyna Hutchins was shot. And these documents were a copy of the script and a copy of the shot list. Specifically, the defense had a keen interest in showing the jury the shot list because it showed instructions for the upcoming scenes for Baldwin to slowly and quietly cock the hammer of the gun. And so this is important for the defense because it tends to show that during the rehearsal when the incident actually occurred, Baldwin was actually following instructions. And this does a couple things for the defense. First, it combats the prosecution's theme of Alec Baldwin is going to do what Alec Baldwin is going to do, regardless of what people tell him in terms of giving him instructions. And it also pushes back on this idea that Alec Baldwin was being reckless or even negligent if he was following the instructions that were laid out for him. Maybe that's convincing to the jury, maybe not, but this is definitely the point that the defense was trying to put forward. Now, on redirect, Special Prosecutor Carrie Morrissey did point out that when the incident occurred, they were not filming a scene. And so this was meant to call into question this idea that the shot list was even really involved in the incident. But although Morrissey does have a point there, as we know, the incident happened during a blocking rehearsal when they were in the process of actually setting up the shots for that next scene. So I do think that there was enough of a connection for the defense to validly make their point here. However, this cross-examination was not without its warts, and I think that a big one came at the end. Here, Spyro grilled the witness on a quote-unquote good Samaritan that came in and brought live rounds that he said had belonged to Seth Kenney. And this person had come in after the Hannah Gutierrez-Reed trial and essentially told law enforcement that they had been duped by Seth Kenney. Spyro's grilling then focused on the fact that Miss Poppell did not send these live rounds to the FBI for any kind of testing. She didn't really formally document this and didn't inform the defense about it. The part that is most beneficial about all of this to the defense is probably the insinuation that this could be some kind of a Brady violation. A Brady violation is where the state violates an essential rule where they're supposed to turn over any exculpatory evidence over to the defense in any case. If they bury it, if they destroy it, or they otherwise discard it, that is the kind of thing that can overturn a conviction. Now, arguments about Brady violations are strictly legal arguments, so they're not really properly put to the jury to decide. That's for the judge to decide. And I don't know what kind of arguments have existed between the parties on this particular issue going into this trial, but I would venture to guess that this has come up somehow. And while we are still here at this point trying this case. But it does feel a little bit shady if the prosecution maybe didn't do what they were supposed to do in turning that over. However, with all of that said, this ended up being another example of something that raised some serious eyebrows when it was brought up on cross-examination, but which, when it came up on redirect, it had a whole different look because of the added context that was able to be provided on redirect. Specifically, Morrissey pointed out on redirect that this quote-unquote Good Samaritan had a name, and it was Troy Testy. And as the jury learned, he is a good friend of Fel Reed, who is the stepfather of Hannah Gutierrez-Reed, who was the armorer who was convicted of involuntary manslaughter in the last trial. So this is somebody who isn't exactly unbiased here who's bringing this in. He may very well have his own personal motive in helping out the Reed family. So it definitely felt, again, like the defense here was being sneaky by not giving proper context to who this person was, and even mentioning the possibility that this person could have their own motive. It just felt a little bit like they hadn't been fully honest with the jury. And so if the jury is going to be making evaluations of trustworthiness between the legal teams, often the case they do, as I've said before, the defense already was looking a little bit shady on day one. And now this continues the same trend that maybe the defense isn't going to give the most accurate or complete picture to the jury. And so, I don't know, this could end up biting the defense in the ass if they continue to do these kinds of things throughout this trial. Anyway, the second witness of the day was the state's fifth witness, Alessandro Pietta. Mr. Pietta is a gun manufacturer from Italy, and so we were delighted with his wonderful Italian accent. If you've been following this channel for a while, you probably have picked up that I love when we come across accents of all kinds, and I just find it so endearing. This was the case throughout the Karen Reed trial with all of the Boston accents, and even the Crumbly trials with the Michigan, Detroit accents that we came across there. Anyway, Mr. Pietta owns Pietta Firearms, a gun manufacturing company in Italy. He also owns EMF, which is the importer for Pietta Firearms into the United States. So what happens is Pietta Firearms transfers the guns to EMF, and then EMF sells them in the US. Mr. Pietta explained that all of his firearms are regularly subject to government regulation and testing, for example, the ATF's drop testing. And of all of these firearms, this includes the single-action revolver that ended up killing Halyna Hutchins. So basically, his testimony was all about establishing the chain of quality control from the gun's manufacturer, ideally all the way up until it reached the set of the Rust film. One thing he did highlight was that because it lived at EMF for a while for the purposes of being used in a showroom for conventions and whatnot, it was manufactured without a firing pin. It's something that could be easily installed when it's actually sold to someone, but this is actually a requirement for gun showrooms apparently because it completely disables the firing mechanism in the firearm. If there's no firing pin in the gun, and someone pulls the trigger, there's no way for any round in the chamber to be struck with enough force that is necessary to actually fire the round. And he also said this revolver is not designed to fire without pulling the trigger, and it simply was impossible for it to fire without that action. Now, in cross-examination, the defense did do a good job of making one limited point, and that is Mr. Pietta hadn't seen the firearm since like 2017, 2018. And as we know, this incident happened in late 2021. So obviously he couldn't speak to the condition of the firearm in 2021 when he actually hadn't even seen it in years. Okay, so the next witness was the state's sixth witness, Justin Neal. He owns a marketing firm that has a branch that handles the sales in North America for Pietta Firearms and EMF. And so he oversaw the September 29th, 2021 sale of this revolver to PDQ, which, as we know, supplied the Rust film set with all of their props. Before this point, he basically had custody of the firearm since like 2017, 2018. And in that time, he primarily took it to trade shows where it would be locked behind glass and inaccessible to the public, except, of course, to look at it. And so he testified to two main things that were important about this particular revolver for the prosecution. One was that the firearm itself was in perfect working condition when he sold it and transferred it over to PDQ. And second, he also confirmed that this revolver absolutely could not fire a round without the trigger being pulled. Okay, so then we got to the final witness of the day. This was Corporal Alexandria Hancock of the Santa Fe Sheriff's Department, who at the time of the incident was Detective Alexandria Hancock. For the investigation, she was initially the secondary detective, but about 2 weeks into it, she became the primary detective on the case. One thing to note is that the defense made mention to the jury in opening statements that the defense didn't anticipate that the jury would hear from the lead detective on the case. And this was, of course, to cast a shadow over the investigation and to suggest to the jury that there's maybe this massive gap that the prosecution is perhaps trying to hide. But although Corporal Hancock didn't finish her testimony on day 2, her testimony so far didn't seem to really leave any of these gaps. But of course, we will have to see if that holds up on cross. Anyway, she testified to a ton of things that we would expect a lead investigator to testify about. And that was the fact that she interviewed Alec Baldwin, Hannah Gutierrez-Reed, and David Halls, and that she executed the search warrants into all of the spaces that were actually searched. One thing that was pointed out on direct examination was the fact that after Corporal Hancock talked to Thel Reed, who of course is the father of Hannah Gutierrez-Reed, the armorer who was convicted in the first trial, Corporal Hancock decided to get a search warrant to look into PDQ's prop house for live rounds to see if they matched the ones that were found on the set of Rust. This was a bit of an important point for the prosecution because the defense keeps suggesting to the jury that the prosecution didn't go down all the investigatory avenues that they should have, and that they limited their search to basically what fit their essentially preconceived narrative as to what had happened here. And so here, this of course shows that Corporal Hancock did in fact listen when someone said, hey, you should look into Seth Kenney. Now, maybe this was just sort of a cursory look, and they didn't look nearly enough. The defense is surely going to bring that up on cross-examination. But at least for now, the prosecution is showing the jury that they did in fact consider all alternatives before making any big conclusions. And along those same lines, Corporal Hancock also testified that she received a ton of phone calls and text messages from Alec Baldwin, who kept reaching out to her independently of lawyers through the investigation. She also said that she was in regular contact with Seth Kenney, who she talked to maybe 5 to 10 times, and who she said that she found to be very helpful to the investigation. She also testified that she was able to get an extraction of Hannah Gutierrez-Reed's cell phone. She said this turned up a number of things, to include a photo of 2 rounds, where the photo had been marked up through the iPhone's photo app. The markups showed a circle drawn around one of the rounds and a word that said dud. And Corporal Hancock described the rounds as starline brass with a nickel primer and a projectile shape that matched the same projectile shape as the live rounds that were found on the set of Rust during the investigation. In other words, these appeared to be a match to those live rounds that they found on the set of Rust. And so, Corporal Hancock said, this was a concern because there already was evidence that suggested Hannah Gutierrez-Reed had brought live rounds on set. But that was all we got for day 2 before Judge Mary Marlowe Summers ended trial for the day. And so it sounds like there is still a lot more to come up in Corporal Hancock's direct examination. And given how long the defense spent on the cross-examination of the crime scene tech, I do expect that we will be seeing a long cross-examination of Corporal Hancock on day 3. Overall, I do think that the prosecution is proceeding through their case in chief and establishing the basic foundation of their case. But in my opinion, there haven't really been any real moments that seem to be big points scored for either side just yet. I will say though, I do appreciate the overall efficiency that this trial appears to be having right now. But those are my thoughts. What do you think? Did you watch the testimony on day 2? Was there anything that stuck out to you as particularly effective? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more Alec Baldwin trial coverage, both in daily recaps and in gavel to gavel live trial streaming, be sure to hit the subscribe button and the notification bell so you can find out when the next one is out. We are just below 250,000 subscribers, and I would love to see us meet that benchmark during this trial. So if you want to be a part of that, definitely hit the subscribe button. And if you really want to support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon, and doing so means that over the long term of this channel, we can continue to devote intensive resources to trials like this one, as well as other interesting legal topics. Links to both are in the description below. Otherwise, see you on day 3.